3 statements are coming, and trust me, each one is a gut punch. Courtrooms aren't just about facts, they're about feelings. Watch closely. Calm words are about to explode into emotional wreckage.
Before I begin, how many people will be making a statement?
3.
We will go on the record in the matter 24 CF79, State of Wisconsin versus James Brown. The state appears through District Attorney James Renicky in person. We have Mr. Brown appearing in person with counsel Eric Pangburn. We're set here today in this matter for a plea and sentencing hearing. The parties have reached an agreement. Mr. Renicky, can you please recite the agreement? Well, first, is there a plea questionnaire waiver of rights form?
There is.
I did review the jury instructions that I have on my computer, but I wasn't able to print them, but we did review them.
So I apologize that they're not attached.
That is okay. Can you please recite the agreement for the record?
My client is going to enter a plea of guilty to counts 1, 6, and 8. The remaining counts are to be dismissed and read in. We're recommending 3 years probation. We didn't discuss any specific conditions of probation. I assume that the court will order what it thinks is appropriate based on the facts. We're not asking for the court to order any additional.
Pause right here. The defense is using time served, 96 days, as a bargaining chip. But think about it. Does 3 months in county really balance out 14 felony charges?
Based on the fact that Mr. Brown did spend 96 days in jail, unable to post a cash bond in the file that was this case before it was dismissed and refiled.
All right. Okay. Mr. Renicky, this is a very serious case. There are 14 felonies, predominantly H felonies with some I felonies and 2 G felonies, making this very serious. 3 of those H felonies are attempts. It has been a global offer with regards to these charges, down to 3 counts, 1 H felony, actually 2 H felonies, and an I felony. Can you please state for the record how this agreement is in the public?
That's like paying pocket change for a wrecked house. Ah, the magic phrase, public interest. Prosecutors always lean on it to justify deals. But public interest for who? The victims.
I believe it's in the public interest, Your Honor, because we're getting a conviction on 3 serious felonies. The defendant does not have a criminal record. It has fairly unique facts to the case. This was a what I would say, jurisdictional investigation. And in terms of the underlying behavior, we think the 3 felonies that he's pleading guilty to adequately cover the actual facts of what happened. And he's taking responsibility not only for the 3 counts that he's pleading guilty to, but he's also agreeing to the dismissed and read in counts, which can be considered at sentencing. And so therefore, we do believe it's in the public interest.
And you are in victims' rights compliance, is that correct?
Yes.
All right. Before I proceed with a plea or taking a plea and moving on to sentencing, I'm going a little bit out of order as I would like to have the victim statements. Ms. Bauer? Yes, please go to that table over there. You can either state your name and or occupation if you wish, or just your initials.
Okay. Noah Lucas Barker, Deputy Burnett County Sheriff's Department. So in the late morning of July 2nd, 2023, I came home from work. I parked my squad car, walked inside my house, and took off my uniform like I always do. I laid in bed and stared up at the ceiling, thinking about what had just happened. I did not regret my actions. I knew what I had done was what we all trained for as law enforcement. Still, I lay there with my mind racing. Did I do everything I could have? Were there other options I could have chosen? I kept telling myself my partners were alive, EMS and fire were still alive, Mr. Brown was still alive. I told myself my wife and daughter still had a husband and father. Over the next couple days, I received numerous calls and texts asking how I was. My response was always the same. I'm fine. I'm glad everyone's okay. I'll see you guys soon. But I was not okay. I was not myself. I did not feel like myself. I would look in the mirror and see an emotionless, pale human that I did not recognize. I was off for work for around 3 weeks. I spent that time trying to distract myself, seeing friends, working on the house, and visiting family. When I did return, I did not feel the same. The world looked different, work felt different. I caught myself second-guessing decisions I made on the job. I caught myself handling calls for service differently than I had before. Over time, the numbness subsided, and I began to see myself in the mirror again. Work and life carried on, and the memory of July 2nd was not always in the forefront of my mind. And now we are here today. In the words of Haile Selassie, throughout history, it has been the inaction of those who could have acted.
Reliving trauma, the court trying to clear its calendar, or the state saving money by avoiding a trial? Here it is, the first victim statement.
The indifference of those who should have known better, and the silence of the voice of justice when it mattered most, that has made it possible for evil to triumph. It is my belief that only 3 years probation for Mr. Brown is allowing evil to triumph. Mr. Brown, due to your actions that night, I made a decision I never thought I would have to make in law enforcement. Your actions took a part in my humanity I will never get back. I hope you find the help you need. Thank you.
Ms. Bauer. Please state your name and/or your initials before beginning.
Corey Ray Barnett. I'm the Chief of Grantsburg Fire Department.
And listen, this isn't about legal jargon. This is about a man staring at his ceiling, wondering if he did enough, while his humanity was slipping away.
July 2nd, 2023 has set me back years. Let me explain. As a Marine, I was deployed to different combat zones and spent a little over 3 years of my life fighting against foreign enemies. I was wounded a few times and once critical, but due to great field doctors, I pulled through. I have seen more in my lifetime than anyone should ever have to. I was single, didn't have children, so I accepted that there was a high probability that I would either be killed in action or scarred for life. I have the physical scars as a reminder of what happened, but the mental scars never go away. When I came home and left the Marines, we were shown the door and expected to adapt back to civilian life. I spent years coping with the physical and emotional pain with alcohol. I never thought I had a problem. I was fine. Once I met my current wife, she saw what I couldn't. She saw the pain. She saw the nightmares and fighting in my sleep. She saw I was drinking to cope with everything as a self-medicating strategy. Only after she became pregnant with our first child, I started to seek help from the VA and trying to put my life back together and become a contributing member of society. There are many ups and downs with my recovery, but with time, things started to get better. I joined the fire department in 2010 and started to put efforts into the community that I lived in. I continued my healing by being in veterans groups and still seeing different doctors. I felt that I was becoming more comfortable in my life and being in public. All this healing to get where it took nearly 15 years of continuous care. I finally got to a point where I didn't need the doctors and the psychiatrists as much as I did. I was in a great spot with my wife and kids and being sober. All of that changed on July 2nd. When my firefighters and I went to help Mr. Brown, who was laying in the roadway, we were just doing that, helping. We all jumped into our roles, trying to make sure that he was okay and what kind of assistance he needed. Knowing that he was a Marine like myself, we were able to talk and keep things somewhat calm after he tried to fight an EMT. All we wanted to do was help. I knew that law enforcement was a ways out and not completely in a hurry because things were under control, and we were able to get him back in his residence. That's when everything changed and my life was sent spiraling back into a dark place. Every Marine is trained as a rifleman first, so every single one of us can pick up a weapon at any time and fight no matter what job you hold. There are 4 weapon safety rules that are ingrained into us from day one of boot camp. Treat every weapon as if it was loaded. Never point a weapon at anything you did not intend to shoot. Keep your finger straight and off the trigger until you're ready to fire. Keep your weapon on safe until you intend to fire. These rules are ingrained into every single one of us, as well as my children and anyone I work with on firearm safety.
That's the real cost, and no plea deal erases it. That split second, gun aimed directly at him, rewired his brain back into combat mode. And legally, that's not just assault.
When James turned the corner into a firing position and pointed a gun at me, I thought I was going to be shot and possibly never see my wife, kids, family, and friends ever again. In all my years in the military, I had a way to defend myself. July 2nd, I was in the open and very vulnerable to whatever he decided to do in that moment. I instantly went back into my killer be killed mentality that I had worked so hard to diminish for my life. I do not have a flight mode within my body. I was trained to fight, and that's just who I am. I never wanted to be put in that mental position again, but there we were. As he came walking back to the fire department, I had to worry about my other firefighters' lives that were still in the hall. My job was to protect them or die trying. My thought went to my wife and kids, and that I never got to say goodbye as my pager sounded to respond to an ATV crash with injuries. They would have had to grow up without a dad and my wife a widow. Luckily, none of that came to fruition. What did, though, is a downward spiral in my mental health. I became withdrawn. I started high drinking again. I became a different person just because of one person in my mind that was ready to kill me and my firefighters. I have missed several weeks of work seeing doctors, becoming sober again, and working on a better person. All that I had accomplished prior to this was completely wiped away in a matter of a few hours. I had to start back over at square one. I've had to get help from my firefighters that thought they were going to watch me die. My life that I had built started to crumble. My wife was ready for divorce because she couldn't stand and didn't want the kids to see what I was becoming. So from that day in July, I fell back to bottom and have spent every day fighting to become better. When I read the plea agreement that was offered, I became more than angry. How is it fair for us that we're affected and continually are? A million thoughts came to my mind. How can someone aim a loaded gun at someone, fight with others, trying to do their jobs, cause psychological setbacks in our lives, get slapped on the hand, and told to have a good day? I was ready for my day in court and James being held accountable. With this plea agreement, I don't feel that there is any justice being served at all. When you can get more jail time for an OW.
That's potentially attempted homicide. Big difference between a shove and a loaded barrel in your face. Think about this. People get more jail time for drunk driving
Someone than actively pointing and ready to shoot someone. This is not justice for myself or any of the others involved. I do not think probation is enough. Thank you.
Thank you. Ms. Bauer?
My name is Trevor Kyle Tex. I was listed as a victim in the case. I am not a victim of what Noah Deputy Barker, Fire Chief Corey Barnett went through. I'm a victim because James made some threats at the hospital. We had to go hands-on and fight with him to the ground. However, when I was informed of the plea deal, initially I thought 3 years of probation for a conviction, to mark a conviction on a sheet of paper. And the DA kind of said that today. We're getting 3 convictions of felony charges. What in that makes this right? Nothing. 3 years of probation for what Mr. Brown put Deputy Barker, Fire Chief Barnett, and the others through. 3 years of probation aren't nearly enough. As a conviction, yeah, we get 3 felony convictions out of, I think, 14 charges.
Or even throwing a punch at a bar, than for pointing a loaded gun at first responders. Fair justice? Or a loophole too wide to ignore? Wait.
3 years of probation ain't nowhere close to what Mr. Brown should have to go through. Thank you.
Mr. Brown, I have in front of me a plea questionnaire waiver of rights form, as well as an addendum to the plea questionnaire waiver of rights form. Did you go over this document with your attorney?
Yes, ma'am.
Can you please pull the microphone closer to you?
A little closer. Yes, ma'am.
Did your attorney go over this thoroughly with you?
Word for word.
And he read it exactly word for word?
Yes, ma'am.
And so you understand everything completely?
Yes, ma'am.
And if you didn't understand something, did you ask him to explain it?
Yes, ma'am.
And he did so?
Yes, ma'am.
You are pleading guilty to 3 counts. Count 1, intentionally point a firearm at a law enforcement officer, a firefighter, an emergency medical technician, etc., an H felony. And as I understand this may not have been a legitimate real firearm, but it was a firearm that was believed to look like a firearm, correct?
Actually, in this case, for count 1, it really was a firearm. It was a 9mm pistol that was...
Stop the tape. This wasn't a fake gun. It was a real loaded 9mm pistol. That detail changes everything. Suddenly, probation sounds less like mercy and more like madness.
This was not the pellet gun or the BB
No,
gun?
the BB gun was the rifle. That was the second event. This particular count was the pistol that actually was a pistol, which was loaded as a 9mm.
All right, so this is an actual firearm, the 9mm firearm that you in fact did point at a law enforcement officer, a firefighter, or an emergency medical technician, a Class H felony. Is that correct?
Yes, ma'am.
And you're pleading guilty to count 6, battery or threat to a judge, prosecutor, or here, in fact, a law enforcement officer, a Class H felony. Is that correct?
Yes, ma'am.
And you're pleading guilty to failing to comply with an officer as a person into custody, a Class I felony. Is that correct?
Yes, ma'am.
And there are 11 other counts that are being asked to be dismissed, but read in for purposes of sentencing. And I'll get over what that means, but you understand that. Is that correct?
Yes, ma'am.
You're 37 years old. You have 13 years of schooling. You can read, write, and you understand the English language. Is that all correct?
Yes, ma'am.
Did your attorney thoroughly go over with you what the state would have to prove as to those 3 charges to find your guilt beyond a reasonable doubt?
Yes, ma'am.
Did your attorney go over with you the maximum possible penalties that you face?
Yes, ma'am.
You are not receiving treatment for a mental illness or disorder. Is that correct?
Yes, ma'am.
Although I thought that I can recall at least another hearing, maybe not with Mr. Pangburn, but previous case where you had a different counsel that you stated to the court that you suffered from some types of mental illnesses or disorders, such as PTSD, perhaps anxiety, or other types of mental illnesses or disorders. Is that correct?
Yes, ma'am.
But you are not receiving treatment for those. Is that accurate?
Yes, ma'am.
Are they affecting your ability to comprehend or understand what's going on here today?
No, ma'am.
Are they affecting your ability to comprehend or understand anything that's happening or affecting this case or anything about this case?
No, ma'am.
Or your constitutional rights or the facts concerning this matter?
So she's asking if you're mental illnesses. Oh, I understand what's going on. No, yes. No, ma'am, everything's good.
You have not had any medications, alcohol, or other drugs within the last 24 hours. Is that correct?
Or ever since I got arrested. Yes, ma'am.
All right. Because you're being charged with crimes, you are entitled to constitutional rights, and each of these rights is listed on this document. Do you understand that by pleading guilty to these charges, you're waiving and giving up these rights?
Yes, ma'am.
You understand you'll no longer have the right to a trial. You'll no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify on your own behalf or remain silent and not have your silence used against you. You will no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty, and you will no longer have the right to have the state prove your guilt to these charges beyond a reasonable doubt. Do you understand all of those rights you're giving up here today?
Yes, ma'am.
Do you understand that if you're not a citizen of the United States, your pleas could result in your deportation?
Yes, ma'am.
Do you understand, with regards to these charges, that with count 1, intentionally point a firearm at law enforcement officers, that the state would have to prove on or around July 2nd, 2023, in Grantsburg, Burnett County, Wisconsin, you intentionally pointed a firearm at or towards the fire chief, Corey Barnett, who was acting in an official capacity and who the defendant knew, who you knew or had reason to believe was a firefighter. Do you understand what the state would have to prove?
Yes, ma'am.
Do you understand that upon conviction of this Class H felony, you face a fine of up to $10,000 or imprisonment up to 6 years or both?
Yes, ma'am.
Do you understand that with regards to count 6, threat to a law enforcement officer, the state would have to prove on or around July 2nd, 2023, in Grantsburg, Burnett County, Wisconsin, you intentionally threatened to cause bodily harm to Sergeant Chad Brugman, a law enforcement officer, without his consent, and at the time of the threat, you knew or should have known that Sergeant Chad Brugman was a law enforcement officer, and the threat was in response to an action taken by the law enforcement officer in an official capacity. Do you understand what the state would have to prove for this Class H felony?
Yes, ma'am.
Do you understand that upon conviction, you face a fine of up to $10,000 or imprisonment up to 6 years or both?
Yes, ma'am.
Do you understand, as to count 8, failing to comply with officers' attempts to take you into custody, the state would have to prove on or around July 2nd, 2023, in Burnett County, Wisconsin, you intentionally refused to comply with an officer's lawful attempt to take you into custody, and you retreated or remained in a building or place, and through action or threat, you attempted to prevent the officer from taking you into custody. While doing each of the above, remained or became armed with a dangerous weapon or threatened to use a dangerous weapon, regardless of whether you had a dangerous weapon. Do you understand what the state would have to prove?
Yes, ma'am.
Do you understand for this Class I felony that you could be, upon conviction, fined up to $10,000 or imprisoned up to 3.5 years or both?
Yes, ma'am.
Did your attorney thoroughly go over the jury instructions in which state the elements that the state would have to prove your guilt for those 3 crimes with you thoroughly?
Yes, ma'am.
All right. Now, do you understand you're pleading guilty to felonies? As such, you will no longer be able to use or possess a firearm for life.
Yes, ma'am.
You will no longer be able to vote in any election until your civil rights are restored.
Yes, ma'am.
Do you understand that there is an offer, an agreement here between the parties for 3 years of probation?
Yes, ma'am.
And that there would be certain conditions that you would need to follow while on probation. Do you understand that this agreement that's been reached between the state as well as the defense is not binding on me, the court?
Yes, ma'am.
Said differently, do you understand that it's my discretion in what I sentence? And for each of these charges, which could mean that I could sentence you up to the maximum possible penalty for each of these charges if I thought it was warranted.
Yes, ma'am.
Do you understand that in my sentencing discretion, I can sentence you with different sentences for each of these different charges? Again, if I thought it was warranted based upon the facts of this case. Do you understand?
Yes, ma'am.
And do you understand that could mean something such as a consecutive sentence for the sentences for the charges, or they could be concurrent? Do you understand that?
Yes, ma'am.
Do you still wish to proceed and enter guilty pleas?
Yes, ma'am.
Do you also understand that there are certain other charges here, 11 other charges that are being asked to be dismissed and read in? Do you understand that by having dismissed and read in charges, you are agreeing that the court, myself, can consider these offenses and that the state is relieved from their obligation in establishing a factual basis for these offenses? Do you understand that?
Yes, ma'am.
Do you understand what that means?
Yes, ma'am.
This is in exchange for the promise that the state will not prosecute you later in the future for these additional offenses, and your slate is essentially wiped clean for all of these crimes. However, do you understand that it essentially could expose you to the likelihood of a higher sentence?
Key moment here. The judge reminds Brown the plea deal isn't binding. Translation: the state and defense may be holding hands, but the judge still holds the hammer. And from her tone, you can feel she just might use it. Let's break this down. Dismissed and read-in charges don't vanish. They lurk in the shadows and get factored into sentencing. It's like erasing ink from the page, but leaving the stain behind.
For the charges that you're pleading guilty to, as long as it doesn't go above the maximum possible penalty. Do you understand that?
Yes, ma'am.
Do you still wish to proceed and enter guilty pleas here today?
Yes, ma'am.
Do you understand that the court looks at character of a defendant